Kabab-Ji SAL, Lebanon, Appellant, and Kout Food Group, Kuwait, Respondent.
Lord Hamblin will explain the Court's judgment.
In its recent decision in Enka Insat against insurance company Chubb, this Court considered how one determines the applicable law to an arbitration agreement where an issue as to its validity arises before an arbitration takes place. The present appeal raises that same question, but at the stage of enforcement of an arbitration award pursuant to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the Convention, which is transposed into English law under Part 3 of the Arbitration Act 1996, the 1996 Act. It also raises issues as to the appropriate procedure on applications for refusal of recognition and enforcement, and the circumstances in which it is proper to adjourn such a decision. By way of factual background, the appellant, Kabab-Ji, a Lebanese company, entered into a franchise development agreement, the FDA, with Al-Hamaizi Foodstuff Company, Al-Hamaizi, a Kuwaiti company, granting Al-Hamaizi a license to operate its restaurant franchise in Kuwait for 10 years. In 2005, Al-Hamaizi became a subsidiary of the Respondent, Kout Food Group, KFG, following a corporate reorganization. A dispute arose under the FDA and linked franchise agreements, which Kabab-Ji referred to arbitration under the rules of the International Chamber of Commerce in Paris. The arbitration was only commenced against KFG, not Al-Hamaizi. KFG argued that it was not a party to the FDA or the arbitration agreements contained in the FDA or the franchise agreements, and took part in the arbitration under protest. The majority arbitrators found that, applying French law, KFG was a party to the arbitration agreements, and, applying English law, KFG was an additional party to the FDA by, quote, novation by addition, and was in breach of the FDA and its linked agreements. They made an award against KFG for unpaid license fees and damages in the principal sum of US dollars 6.7 million. KFG applied to the Paris Court of Appeal to set aside the award. Soon afterwards, Kabab-Ji issued proceedings in the Commercial Court in London to enforce the award. KFG made a cross-application for an order that recognition and enforcement be refused. On a trial of preliminary issues relating to the FDA, which would be determinative of the like issues arising under the linked agreements, the Commercial Court held that the validity of the arbitration agreement in the FDA was governed by English law, and that, subject to a point left open, as a matter of English law, KFG was not a party to the FDA or the arbitration agreement. The Court postponed making a final decision on enforcement pending the decision of the Paris Court of Appeal. Both parties appealed to the Court of Appeal, which upheld the judge's decision, say that it held that the judge should have made a final determination. It held that there was no real prospect of it being shown that KFG became a party to the arbitration agreement and that summary judgment should be given, refusing recognition and enforcement of the award. Kabab-Ji appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal on all issues. The judgment was given by Lord Hamblin and Lord Leggett, with whom Lord Hodge, Lord Lloyd-Jones and Lord Sales agree. Three principal issues arise. Issue 1, the choice of law issue. The Convention provides a limited and exclusive list of grounds on which the recognition and enforcement of an award may be refused. The ground relevant to this case is that the award is based on an invalid arbitration agreement. As discussed in Enka, Article 5(1)(a) of the Convention establishes two uniform international conflict of laws rules. First, that the validity of the arbitration agreement is governed by, quote, the law to which the parties subjected it, i.e., the law chosen by the parties. Second, where no law is chosen, the applicable law is that of, quote, the country where the award was made, generally the place of the arbitration seat. When assessing whether an agreement exists or is valid, the Court uses the law that would apply if it exists or is valid. As stated in Enka, a general choice of law to govern a contract containing an arbitration clause will normally be a sufficient, quote, indication of the law to which the party is subjected in the arbitration agreement for the purposes of Article 5(1)(a). The principles for identifying the applicable law should be the same, whether the question is raised before or after an award has been made. Applying these principles to the present case, the effect of the relevant clauses in the FTA is plain. The FTA's governing law clause provides that the, quote, this agreement, close quote, shall be governed by English law, and this clearly extends to the arbitration agreement. Issue 2, the party issue. Kabab-Ji contends that KFG became a party to the arbitration agreements by becoming a party to the FTA by novation, as a result of the party's conduct and the performance by KFG of various contractual obligations over a sustained period of time. It cannot, however, point to any agreement in writing to this effect between itself and Al-Hamaizi. The FTA contained a number of provisions which prescribe that it may not be amended save in writing, signed on behalf of both parties. No oral modification clauses. As held by the Supreme Court in MWB Business Exchange against Rock Advertising, such provisions are legally effective. These apply to the termination of the FDA, which would be necessary for there to be a novation, as well as to the requirement of consent. The contractually agreed procedure for the provision of consent to any modification of the contract was required to be followed, unless a relevant estoppel could be established. No evidence to support the making of the requisite representation for an estoppel has been identified, and, even if there was such evidence, it would not necessarily affect the position of KFG. The no oral modification clauses are therefore an insuperable obstacle to Kabab-Ji's case of novation. Issue 3, the procedural issue. The Convention and the 1996 Act require a party resisting enforcement of an award to, quote, furnish proof of a ground of refusal. When a party argues that there was no valid binding arbitration agreement, the English court must determine the issue for itself in accordance with its own procedural rules. The court rejects Kabab-Ji's submission that this requires a full evidential hearing and trial of the issue. A summary approach is suitable where it is appropriate and proportionate. The Court of Appeal was also correct to overturn the judge's decision to adjourn the decision on recognition and enforcement under Article 6 of the Convention and Section 1035 of the 1996 Act. In circumstances where the French court will apply French law to the question issue, whilst the English court will apply English law, the risk of contradictory judgments cannot be avoided. Nor in these circumstances would the French court's decision be relevant to the determination of the English court, a consideration ignored by the judge. The appeal must therefore be dismissed.